So to supposedly connect you to the strawman which they created for you when your birth was registered, they use the legalese technique of conning you with the name of the strawman. If you are ill-advised enough to go to a court, which is a corporate place of business, as the accused, you will be asked to confirm your name, quoting the full name shown on your birth certificate, which is the legal personality. Titles such as Mr., Drive, Lord, PC, QC, or whatever are not asked for as they are not required. The accused is actually the legal personality which is the name on the birth certificate, so when they ask for the person's name, they are talking to the legal personality and not the human. This is because a human cannot exist in the legal world, only pieces of paper can, and that is something which they are very careful not to tell you. This is a really key issue. Natural law and common law are the only laws which apply to humans, and they deal only with harming other people or causing them loss, and outside of those restrictions, a human has free and unlimited entitlement to do anything he chooses which complies with these principles. As opposed to this, acts of parliament, statutes and statutory instruments contracts do not apply to the human but only to the piece of paper which is the legal personality and which has no reality. As the legal fiction of the legal personality was created by the company called the United Kingdom Corporation, it is that company which gets to say what the rights and duties are for that piece of paper. When a person is born in Britain, the mother and father submit a birth certificate registration form, which is a piece of paper. There is no requirement under common law to do this. When any limited company or corporation is set up, there is always a certificate of registration in order to create its legal personality, and that is a piece of paper. Please note that a British birth certificate states quite clearly that it is not evidence of identity. That means that it has nothing to do with any human. Marked on it is Crown copyright, showing clearly that it does not belong to an individual and was created by the Crown. This act of registering a child makes that child a ward of the court, and the child can be taken away from the parents at any time. The legalese definitions of words which sound commonplace can be found in Black's Law Dictionary, and the current edition is the 8th. Interestingly, in legalese, you the human are defined as a monster, which shows exactly what the people who use legalese think of you. Charming people, aren't they? Another trick they try to play on you is to imply that a summons is something which you must obey, while in fact, it is only an invitation to attend their place of business. They are not inviting you, the man, but instead, they are inviting a legal personality to their place of business, and please note that there is a choice as it is only an invitation. The legal personality is just a piece of paper, a birth certificate created by the commercial company called the United Kingdom Corporation, and it is not the human. You can't be forced into a contract, so they have to deceive you into entering into one without understanding what you are doing. They are using deception, as every magistrate's court is a trading name of the commercial company called the Ministry of Justice, DUNS number 22549-8526, which does not have a parent company listed, meaning that it is a parent company itself. Legal people, on being shown this company registration, responded by saying that if this information is genuine, which it is, then the UK has been lawless for more than 400 years because the whole justice system is being dealt with by a commercial company. Going to court in connection with any civil action is a very bad idea, as the only function of a court is to judge between two parties who disagree and then penalize the loser. The court doesn't care who wins or loses, and the objective of the court is to make a profit for its owners, as it is a commercial enterprise and its purpose is to acquire money from anybody who is fool enough to attend. If you look at the summons, which is really an invitation to go to court, you will see that it is not in your name, but in the name of the strawman which they are hoping to fool you into representing. Dealing with debt because of the very high percentage of the money earned being taken away from the average person, it is not unusual for people to end up with what looks like debt. Most people spend their time worrying over the statement of what they are told they owe, and do endless calculations to see if they agree with the numbers which they have been sent. Again, this is the sort of misdirection which magicians use to fool audiences, distracting their attention away from where the action is really taking place. Here, the question is really not how much is owed, but instead it is anything actually owed? 9. You need to remember that any financial institution is a legal fiction and does not actually exist. As a result of this, it can only deal with other legal fictions, essentially, other pieces of paper, and it can't have any dealings with a man or a woman, as they are not legal fictions. It is also important to understand what passes for money nowadays. Let's say our trusty friend James Martin goes looking for a loan, and he fills in an application form with the Swindle Bank Limited for £10,000. Interestingly, the form which he is asked to sign says that he has already received the £10,000, although the loan has not yet been approved. The next day, the loan is approved and James is handed a check which he is asked to sign and lodge to his account with the bank. We won't follow up on that very interesting procedure at this time, but please remember that he has now provided 2 signatures for £10,000 in the Strawman name, and all he has received is a 1 and 4 zeros in the accounts of the Swindle Bank Limited. All goes well for several months until James loses his job and does not manage to get another one. This is financial trouble which he does not know how to deal with. Time goes by and James has not had sufficient money to make payments against his loan from the Swindle Bank Limited. He starts getting letters from the bank saying that he must pay the arrears immediately and keep up with the payments in future. There is not the slightest chance of that happening as James just does not have the money and he does not know what to do. Fortunately, Peter, the next-door neighbor of James, happens to be an independent financial advisor with years of experience, and James has the brainwave of asking him for help. Peter is willing to help and so he sits down and goes through all of the paperwork. Then he tells James, "You must not ignore this situation. Write back immediately and say that you agree to pay any financial obligation which you might lawfully owe, on condition that they 1. Provide validation of the debt, that is, the actual accounting. 2. Verification of their claim against you, that is, a signed invoice. 3. A copy of the contract binding both parties, you and them, and send that letter by recorded delivery so that there is an independent witness to it having been delivered. Every letter you write should be marked clearly without prejudice, which means that you reserve all your lawful rights and accept no contract unless it is shown to be lawful by meeting the 4 conditions essential to a lawful, binding contract, namely 1. Full disclosure, you were not told that you were actually creating the credit with your signature. 2. Equal consideration, they brought nothing of value to the table and so have nothing to lose. 3. Lawful terms and conditions, yours were actually based on fraud. And 4. The signatures of both parties, corporations can't sign because they have no right or mind to contract since they are soulless legal fictions, and no third party can sign a contract on their behalf. Peter then tells James that agreeing to pay, provided that evidence of a lawful debt can be produced, stops him being taken to court because courts only adjudicate between parties who are in dispute, and as James has agreed to pay, there is no dispute, so the court would not accept any application for a hearing. If the Swindle Bank were foolish enough to try, James has only to send the court a copy of his letter agreeing to pay and the case would be thrown out immediately, and the bank might well be penalized for wasting court time. The bank is now in trouble as it has been running a con game on James and so can't produce the documents for which James has asked. The request by James was reasonable in every respect. However, a loan agreement is a contract and so there has to be full disclosure of all the details, which there wasn't. Both sides have to put up something of equal worth, which didn't happen, and the contract has to be signed by both parties, which the bank can't do. So, the bank has a real problem. The bank will probably send a statement of what it wants James to believe is the outstanding amount. James should return this with a polite note saying that a statement is not an invoice, so would they please provide a signed invoice as requested. They will also probably send a photocopy of his loan application form, at which point James should write back and point out politely that it does not constitute a contract as it is only signed by one of the parties, himself, and he has asked for a copy of the contract signed by both parties. The bank is likely to go silent at this point and stop corresponding with James. James should then write again, requesting that the necessary documents be sent to him within the next 14, or perhaps 28, days, and if that does not happen, then he will consider the debt to be fully discharged. The bank will either remain silent or write back to say that the debt is fully discharged. If the bank tries phoning, then just tell them politely that you only wish to deal with this matter in writing, and ring off. If the bank remains silent for the stated period, then James should write back stating that due to the bank's failure to provide the necessary evidence of a lawful debt within the reasonable time provided, that James now considers that the debt is fully discharged and ask the bank to confirm that in writing. The bank will normally write back confirming that the debt is fully discharged and that there is nothing owing, and if it does not do that, then it will just stop asking for any further payments. The reasons for how and why this takes place takes a good deal of explaining and many people find it difficult to understand. So, it is covered in detail here. Many people think that this process sounds like you're ripping off the bank, but this is definitely not the case. What is money? Originally in England, the unit of money was called £1 sterling. That was because it was literally sterling silver weighing 1 pound. As it was quite difficult to carry several pounds weight of currency round with you, it was arranged that the actual silver could be held in a bank and a promissory note, which was essentially a receipt for the deposit of each pound of silver, was issued. It was much easier to carry these bank notes around and to do business with them. If you wanted to, you could always take these notes to a bank and ask for them to be cashed, and what happened then was that the bank would hand you the equivalent weight of sterling silver in exchange for the notes. 11 Today, the currency in England is still bank notes, which are certainly easier to carry around, but there is one very important difference. These notes are issued by the private company called the Bank of England, which is as good a name for a company as any other name. However, if you were to take one of their bank notes to the premises of that company and ask for it to be cashed, all that they would do is give you another note with the same number of pounds written on it, or alternatively, some other notes with smaller numbers printed on them. This is because, unlike the original bank notes, there is nothing of any physical value backing up the bank notes of today. They are only worth the physical paper on which they are printed. It actually gets worse than that. What happens most commonly nowadays is that they do not even bother printing those pieces of paper. Now, they just tap some numbers into a computer record, or if they are old-fashioned enough, they write the numbers into a ledger. What do those numbers represent? Nothing at all. They have no actual value. In other words, just as much value as if you type them into your own computer, quite meaningless. And yet, a bank or other financial institution will merrily lend you those numbers in return for years of your work. Now, isn't that really generous of them? Actually, this is not at all funny, because if you don't keep paying them money earned by your very real work, then they will attempt to take your house and possessions away from you. This won't happen if you understand that what they lent you was actually valueless. Take the case of Jerome Daley of Minnesota in America. In court, Jerome challenged the right of the bank to foreclose on his home, which had been purchased with a loan from the bank. Jerome argued that any mortgage contract required that both parties, that is, himself and the bank, to put up a legitimate form of property for the exchange. In legal language, that is called a legitimate consideration put forward by both parties to the contract. Jerome explained that the money was in fact not the property of the bank, as it had been created out of nothing as soon as the loan agreement was signed. That is, the money does not come out of the bank's existing assets, as the bank is simply inventing it, and in reality, the bank is putting up nothing of its own, except for a theoretical liability on paper. As the court case progressed, the president of the bank, Mr. Morgan, took the stand and admitted that the bank, in combination with the privately owned commercial company called the Federal Reserve Bank, created the entire amount of the loan and credit in its own books by means of a bookkeeping entry, the money and credit coming into existence when they created it. Further, Mr. Morgan admitted that no United States law or statute existed which gave him the right to do this. A lawful consideration must exist and must be tendered to support the loan agreement. The jury found that there had been no lawful consideration put forward by the bank, and so the court rejected the bank's application for foreclosure, and Jerome Daley kept his home. That is exactly the situation with all British mortgages. When someone makes an application for a mortgage or any other loan, the applicant's signature is required on the application form before the loan is approved. That signed application is a valuable piece of paper which the bank can lodge in its accounts as a credit to the bank for the 12 amount of the loan. The bank could just keep that application form and stay £100,000 or whatever ahead, but they want more, much more. They want the borrower to pay them that same amount again, funding it by years of work, and not only the amount of the supposed loan but significant extra in interest. Why do you think that they are so keen to lend you money? They are even willing to lend to people with very poor credit records, as there is no way that the bank can lose out on the deal, no matter what happens. This is why, if a company starts demanding payment of large sums of money, you start by asking them to provide the accounting for the deal. In other words, you are asking them to show in writing that they provided something of genuine worth as their side of the loan contract. As they invented the money as numbers in their books with no real worth attached to those numbers, they are in deep trouble as they can't comply with your demand to see their accounting for the deal. Did you ever wonder how the average bank manages to make hundreds of millions of pounds profit every year? Well, you are looking right at where a large chunk of it comes from.